here with Bert Brandenburg, Executive Director of Justice at Stake campaign. Bert was just on an excellent panel on judicial elections. And Bert, would you mind addressing Caperton versus Massey, which just came down recently in the Supreme Court?
Sure. Caperton v. Massey, at its heart, was an issue about campaign cash and our courts. In judicial elections around the country, we've seen enormous amounts of money coming in from interest groups, partisans, and attorneys who then appear before the very judges to whom they contribute and to whom they often make the difference in helping to elect to the bench. So in the Caperton case in particular, you had a situation where a justice on the West Virginia Supreme Court had been elected with $3 million in support from a particular CEO. Meanwhile, there was a case that was already underway even before he was elected involving this one CEO and another business, and at stake was a $50 million jury verdict. So after the CEO of Massey helped elect Justice Benjamin to the West Virginia Supreme Court, Justice Benjamin then became the tie-breaking vote overturning the $50 million jury verdict against Caperton and the company. And as a result, the other business said, wait a second, as a matter of constitutional due process, a judge really ought to step aside when that much money is involved. And the U.S. Supreme Court took the case and heard arguments this past winter and decided just a couple of weeks ago that indeed that was correct, that the justice needed to step aside, that at least in this case the situation was so extreme that recusal was called for. And now we will see what states around the country do in terms of changing their own standards. And I think the culture of judicial elections is changing, so the culture of what judges need to do, has to change as well. And I think we probably will see some changes. But in addition, as we discussed today at the panel, there are a lot of other solutions out there that complement recusal. Some jurisdictions may want to move away from contested elections to a merit selection system whereby you have a screening committee help identify strong candidates. Someone then gets appointed to the bench and stands in a retention election before the voters periodically. If a jurisdiction wants to keep contested elections, then in particular strong recusal rules will be needed, but in addition all the things you can do with regular elections to insulate people from special interest politics are available. So you can have public financing of judicial elections, which North Carolina and New Mexico have now had for a few years, and which Wisconsin is considering, so that judges don't have to dial for dollars from the very parties who appear before them. You can have contribution limits, you can have better disclosure laws, which is going to be particularly important in the area of independent expenditures, because in judicial elections, as with other elections, we increasingly see outside groups who are spending big money, often on advertisements that have nothing to do with their own agendas, simply because they think they can move a particular person onto the bench or off the bench. And they are spending the cash as an investment. And I think the system needs to make sure that that's not what happens in the end, that there shouldn't be a link between money and justice. The public shouldn't have to worry about whether a contribution is affecting the outcome of a decision in the courtroom.
Thanks so much for addressing this important topic.
You're welcome.